The chair now lays out Senate Bill 718, and recognizes its author, Senator Paxton, to explain the measure. Senator.
Thank you, Mr. Chairman, and thank you, members. Many Texas children have parents who share custody due to a divorce in their family. In Texas family court, if one parent is determined to have been falsely accused of neglect, judges are not required to rule that the falsely accused parent get back the custody time with their child that they missed during the investigation. Senate Bill 718 seeks to remedy and prevent injustice against parents who face unfounded allegations that impact their child custody. If a parent is found to have been falsely accused of neglect, this bill would make it so that judges would be required to grant that parent the custody time they missed out on because of the false accusations. Thank you, Mr. Chairman and members, for your consideration. I became aware of this issue because of the story of a constituent, and Mr. Robert Garza, who has been invited by me to testify, but I appreciate your consideration.
Thank you, Senator Paxton. Members, any questions for the author? Very well, we have invited testimony on Senate Bill 718, so the chair calls Robert Garza. Robert Garza testifying for Senate Bill 718. Mr. Garza, get comfortable there, pick a seat, and when you're ready, introduce yourself and give us your testimony. Welcome.
Thank you. Thank you for your time.
Make sure you get close to the mic so we can hear you too.
Thank you for your time. This bill fixes a fundamental parental right that is at stake, in which only was taken on precaution by the court. This bill brings healing and allows the child-parent relationship bond to be rebuilt from the time that was taken only on precaution. It is, as it's written now, it puts the burden of proof on the parent to prove why they should have the time back, which also requires another hearing or filing, which could cost thousands of more dollars and delays and more time lost to get that hearing. It should not cost in Texas, a fit, willing, and able parent $700,000, 12 years in court, and over 43 false CPS allegations. 12 years in court with over 43 false CPS reports. I could have been jailed or imprisoned at any point. All allegations were false. We had 2 home studies, 2 psych evals, 2 parent facilitators, 2 amicus attorneys, several therapists, and several judges. In 12 years, our children and I have been in court. We've lost about 2.5 to 3 years of that time that was taken only on precaution. The longest I went without seeing our children was 3 months with 1 false allegation. The court always gave the children back. Every time the court did this, and they always did, and my attorney always did ask for the time back, the court would say, let's just move forward. Let's just hit the reset button. When my attorney pushed for the issue, the judge ruled that we would save it for final trial. Final trial came 10 years later with all the games that were played. 2 to 3 times final trial was delayed due to a new CPS report being opened. CPS had to have their case closed to go into final trial. CPS would have 30 to 60 days to finally investigate the case and rule it out. Then opposing counsel would supposedly have no dates open for 2 months. Then that pushed it out for months. By that time, the psych eval would have to be updated due to the Texas rules. Then the home study would have to be updated. 1 psych eval, just the update, took 1.5 years just for the update. The biggest travesty in my case, besides what was done to our children and me, was my ex was able to abuse the CPS resources in district attorney's office in 2 different counties. This bill would give those resources back to the offices and unstop the court system by taking the incentivization out of making the false allegation.
Thank you for your testimony. Thank you for sharing your experience. Members, any questions for the witness? Thank you for being here.
Thank you.
Public testimony is now open, and the chair calls Steve Bresnan and Laura Alter. Steve Bresnan, Laura Alter. Come on down and get situated.
Good morning.
Mr. Bresnan, looks like you registered first. Do you have a preference, or will you go first?
Seems like the right thing to do to defer to Ms. Alter.
I asked you because I knew you'd say that. Thank you, Ms. Alter. Introduce yourself. Give us your testimony.
My name is Laura Alter. I'm a parent volunteer with the National Parents Organization, a nonprofit that works on behalf of children to protect their right to access both of their parents when their parents live apart. I'm also head of marketing for an energy logistics firm here in Austin, and I'm mom to 5 kids, ages 13 to 25, and 3 bonus kiddos, ages 15 to 20. Thank you for the opportunity to share my thoughts on this bill. I'm here today on behalf of every child who's ever been denied court-ordered access to one of their parents by another parent, a legal guardian, or the Department of Family and Protective Services, and the law did not protect them by ensuring their access was enforced and restored. SB 718 would be a tool to defer interference behavior by requiring that make-up time is ordered for the child unless there is good cause not to do so. There are 2 points that I'd like to make. The first is why this bill is necessary. The second would be related to Texas resident viewpoints on this topic. First, most people are really fortunate to have almost no understanding of this problem that this bill aims to solve. But if you know, like Mr. Garza, you know that the effects on a child can be devastating. Penal Code 2503, interference with child custody, indicates that interference is a state felony in Texas. However, district attorneys typically do not force it. Why? Parents are often told if they're standing in a location to exchange the child to get possession per the court order. If they call the police, they're typically told it's a civil matter, not a criminal matter, despite the felony status. If you dig a little bit deeper, you learn that nobody wants to jail a parent. That would be devastating for the child. So what options do we have? That's where this bill comes in as a deterrent. Is that time?
If you have something else, you can go ahead and wrap it up. We don't want to cut you off if you got something to close with.
Yes. I'll just close with, there is a handout. Apologies if yours is not as pretty, best intentions. There are 2 questions on this handout. This is a poll done July of 2022, Texas state residents, and we just wanted to know their opinion on this issue. What role does the law have in protecting a child's right to access their parents, both of their parents, if they're being raised in 2 homes, and should there be enforcement? And it's pretty clear with over 90% support that children in the state of Texas need us to act in order to protect them and serve their best interests in the way that 718 would. Thank you.
Thank you for your testimony. Mr. President, introduce yourself. Give us your testimony.
Thank you, Mr. Chairman. My name is Steve Bresnan. I'm here on behalf of Texas Family Law Foundation. Proud to support Senate Bill 718 and be working with Senator Paxton on yet another family law bill. Thank you for bringing the bill. It's unfortunate that people sometimes have to go to court to get what they've already gotten from the justice system enforced. But I believe in the decade and a half that I've been representing the family lawyers, this is probably the single biggest complaint that people have had. They go through the process, they get time allocated, they order their lives around that time, and then one parent or the other doesn't comply with the law, and they have to go in and they have to prove that they've been denied and they're entitled to have that time back, because the law says the court may restore that time. This bill changes may to shall, directs the courts to do it, and it shifts the burden to the defendant in the lawsuit to show good cause why that time should not be restored. That's a very significant legal shift, shifting the burden. I think the bill would disincentivize people from denying if they know that the courts will restore that time. It will disincentivize people from filing false claims with DSPS to harass or use the state to interfere in that relationship. We strongly support this bill on behalf of the hundreds of volunteer members of the Texas Family Law Foundation. Happy to answer any questions.
I thank you for your testimony. Senators, any questions for either or both of our witnesses? Very well. Thank you for being here. Thank you.
Thank you again. Thank you, committee members, for your service to Texas.
Thank you. Ditto.
Is there anyone else wishing to testify on, for, or against Senate Bill 718? Seeing and hearing none, we'll close public testimony. Bill be left pending at this time. The chair now lays out Senate Bill 718 by Senator Paxton. This is Senator Paxton's bill regarding possession and access to a child. Senator Paxton moves that Senate Bill 718 be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt. Birdwell. Lamantia. Menendez. Middleton. Parker. Perry. Schwartner. Zaffarini. Paxton. Hughes.
Yes. There being 8 ayes and no nays, the bill will be reported favorably. Senator Paxton moves that Senate Bill 718 be recommended and certified for placement on the local and uncontested calendar. Is there objection? Seeing none, it is so ordered.